Tonight's webinar is by Miller Thompson, one of Canada's most respected law firms, with over 500 professionals practicing in 11 offices across the country, including Toronto, Markham, Kitchener-Waterloo, Guelph, London, Vancouver, Calgary, Edmonton, Saskatoon, Regina, and Montreal. They go beyond a strict technical analysis of the law. In providing advice, they take a practical approach that combines legal knowledge and analysis with risk management, quality improvement, cultural, structural, and resource considerations. Their team-based practice ensures that issues are addressed at the appropriate stage and form part of their risk-managed approach to legal services. Miller Thompson's health industry practice is one of the firm's key industry-focused teams. They have a consistent track record in providing practical, creative, and cost-effective advice, combined with an unyielding service commitment to their clients and to the communities in which they practice. Our speakers tonight are Meg Berkowitz and Sasha Siegel. Meg is a lawyer at Miller Thompson LLP, practicing exclusively within the health industry. Meg's practice focuses on providing corporate, commercial, and corporate governance advice to private and public health and social service organizations and industry associations. Meg assists clients with contract matters, integrations, corporate structuring, procurement, mergers, and program transfers, intellectual property, and other general commercial matters. Sasha Siegel is a labor and employment lawyer at Miller Thompson LLP. Sasha provides her clients with practical, timely advice with respect to a variety of labor and employment law issues. Sasha also assists startup companies with navigating their labor and employment law obligations. Sasha has prepared numerous employment contracts, workplace policies and procedures, and has assisted with the development of workplace training. Welcome, Meg and Sasha.
Thank you so much, Cheryl, and thank you everybody for joining us this evening for our session on associate agreements legal considerations. We have a lot of material to cover this evening, so we'll dive right into our presentation. And the first thing we're going to do is get you to participate with us in some live polling questions. So the first question that we'd like you to answer is whether you currently engage associate optometrists in your practice, whether they are employees or independent contractors. And if you are an associate optometrist joining us today, obviously feel free to answer this question as well and modify it to read whether you are an associate that is engaged in practice with somebody else, whether you're an employee or an independent contractor. So we'll give you a few seconds to answer this question, and we'll share the results with you as they come in. So the results are up on the screen, and it's about an equal split actually. So about 57% of you said that you currently engage associates in your practice, and 43% don't yet do that but may do it in the future. And so we'll move on to our second polling question. And our second question is, if you currently work with associates in your practice, how are the associates engaged? Are they employees? Are they independent contractors? Or is there a mix of both employees and independent contractors? And again, if you're an associate joining us this evening, how are you engaged in the practice? Are you an employee or are you an independent contractor? So we're just going to wait a few more seconds. And we see that the vast majority of you, if you engage associates in your practice, you engage them as independent contractors. A few of you engage them as employees, and a small percentage of you have a mix of both. And so our third poll question for this evening is regardless of how you engage with the associates in your practice, whether employees or independent contractors, do you have a written agreement in place? And if you're an associate, have you had to sign a written agreement in order to be an associate in an optometry practice? Okay, so we have the results in, and the majority of you said that you do have written agreements in place with your associates, and about 30% of you don't have written agreements in place at the moment. And so these are really, important questions to consider and think about as we go through our session today. And so we'll dive right into the agenda. So first, we're going to take a brief look at the regulatory requirements. Then we're going to dive into engaging with associates, whether they be employees or independent contractors. And we're going to look at it from both a CRA perspective as well as an employment law perspective. We're then going to talk about some key terms you'd be looking to find in agreements with associates. And as part of that as well, a very important component is protecting your practice goodwill, which will speak to restrictive covenants and non-solicitation and non-compete clauses. And then we're going to summarize our presentation. So like Cheryl said, my name is Meg Berkovitz, and I'm joined this evening by my colleague, Sasha Siegel. And so we are going to dive right in. So a quick review of the regulatory requirements. So the General Regulation to the Optometry Act has a definition for independent contractor, and it defines an independent contractor as a person who practices the profession, in this case optometry, under an agreement with another, but who is independent and not controlled by the other or subject to the other's right of control in respect of the member's conduct in the practice of the profession. Now, it's really important to keep in mind that as optometrists, you're required to enter into written independent contractor agreements when engaging in the practice of optometry, but that requirement does not apply when you are engaging with associate optometrists or actually other physicians that are in the practice of medicine. So that requirement around the written independent contractor agreement in the Optometry Act, in the regulation to the Optometry Act, really only applies to opticians, optical corporations, and other third parties. And so the College of Optometrists does have some guidance documents on determining the relationship of an independent contractor. And again, like I said, this guidance document is not actually applicable to associate agreements. So when we're speaking about independent contractor agreements this evening, we'd like you to keep in mind that this is not the same independent contractor agreement that's referred to in the regulation and by the college in their guidance documents. The college does have some considerations for you to look at on whether individuals are independent contractors, and those considerations include risk and control. And those risk and control factors do in fact also play into a CRA determination and an employment law determination of whether an individual is an employee or an independent contractor. But the CRA and employment context actually goes into a lot more factors when making that determination. So risk and control from the college's perspective are not the only things that we're looking at when we look at independent contractor or employment consideration in this sphere. And so what are we talking about today? We're going to be talking about employees versus independent contractors, both from an employment law perspective, and we're going to look at the factors that the CRA considers when making a determination of independent contractor or employee. And so I'll pass it on to Sasha to speak about the employment law considerations.
Thank you, Meg, and good evening, everyone. Thanks for joining us. So I'm just going to go over some of the main factors from an employment perspective that are considered in this analysis of employee versus independent contractor. And the important thing to remember is there's no one factor, no one determinative factor that will kind of be yes or no. If this is true, yes, you're an employer, an independent contractor. It's more looking at all of these factors overall and making a determination as to whether someone's, really an employee or an independent contractor. And I think you'll see a bit of overlap in terms of the CRA perspective, which Meg will get into after. So from an employment law perspective, some of the factors that are considered is kind of this idea of instructions or directions. So from an employment perspective, typically an employee is directed by their employer on what to do, how to do their work, when to do it. And an independent contractor, on the other hand, typically decides how to do the work on their own. They have a lot of flexibility and freedom in terms of how they do their work. They're not really taking instructions from anybody, and they're usually able to work on their own schedule. Another factor that's important is this idea of training and supervision. So in a typical employee context, the employer-employee context, employers tend to train and supervise their employees. And employees will be required to go to certain training. They'll be required to follow specific instructions again, and if they don't, there could be repercussions because they're being supervised by their employer. Again, an independent contractor, on the other hand, typically doesn't receive training. They're being engaged because they already know what to do, and they're typically not following instructions. They already know what to do. They're using their own methods, and they're not bound to supervision from the person or organization that's engaging them. Another factor that is considered is this idea of personal service. Typically in an employment relationship, the individual is being hired to provide service personally. So take a typical example of shoppers hiring a cashier. They're hiring that cashier to perform the services personally to shoppers. And that cashier can't go and hire somebody else to do their work. On the other hand, an independent contractor typically does have the ability to hire others to do their work. That's not always the case, and sometimes that just can't happen, but it is one factor that's considered. The hours of work is another key factor that's considered. In the employment relationship, typically the hours of work and the days of work are set by the employer. In an independent contractor relationship, again, typically the contractor would choose whatever hours they want to work. They'll say, I'm available to do services for you, on these days from X time to X time. And it's up to them when they want to provide services to you. Another big factor is the idea of, typically in an employment relationship, it's full-time. Somebody is committing full-time to you, not necessarily, right? There's sometimes part-time employees, but they're typically, someone would be engaged full-time, and you wouldn't want them to be performing work for others if you're a full-time employee. An independent contractor, on the other hand, you want the relationship to be non-exclusive. That's truly one of the big factors in an independent contractor relationship, is they're free to choose when they want to perform services for you, and they're free to choose whom they do it for. So they're not limited to just providing services to one organization. The next factor is this idea of order or sequence of work, and we've kind of touched on it already, but it kind of goes back to that, how much control does the individual have over how they do their work, when they do their work. And so again, this goes into this idea of who has more control in an employment relationship. Typically it's an employer that is directing how the work's done, the sequence of the work, whereas a true independent contractor, they decide their own pace and how they want to do it. Method of payment is another factor that's considered from an employment law perspective. And what I mean about that is, in a typical employment relationship, you might see someone paid an annual salary or an hourly wage. Whereas an independent contractor, it may be a little different. Sometimes they're paid for a particular project. Sometimes they're paid, a flat fee to do something, or they're paid commission. And typically an independent contractor would actually charge HST. I know that Meg might talk a little bit about that. But an employee is not going to charge HST to their employer. Licenses, this talks more about in an employment relationship, the organization tends to hold the license to do the work that's required of the individual, whereas in an independent contractor relationship, the individual typically holds the license to do the work. Another factor is this idea of serving the public. An independent contractor will often kind of have their own profile that they're advertising. Sometimes they have their own office, they have their own business perhaps. They invoice customers on their own. Whereas an employee, they're not typically having their own office. They're usually being directed where they work in terms of, an employer's place of business. And they're usually not doing kind of this business on the side. It's a little more exclusive. And so I think I'll pass that back to Meg to kind of cover some of the CRA factors, which I think you'll see a bit of overlap there.
That's right. So there is quite a bit of overlap you'll see as we go through the different criteria that the CRA considers from the CRA perspective and the employment law perspective. And so the CRA does have a number of criteria for determining whether an individual is an employee or an independent contractor. And they do have a publication that's available online that goes into a little more detail. The publication number is provided on the screen, and we will be providing a copy of the presentation to you. It will be made available through the OAO once the session is over. So, if you're suffering from insomnia and you need some bedtime reading, you can look up the CRA publication on employees versus independent contractors and have that help you put you to sleep. But the CRA criteria that the CRA considers are all listed on the screen there for you. So the degree of the financial risk, which kind of goes hand in hand with a chance of profit for the individual, control over the worker, the ownership of tools and equipment, the ability to subcontract and hire helpers, the degree of responsibility for investment and management held by the worker, and really any other relevant factors that the CRA determines they will consider. And the determination of an employee versus independent contractor is very fact specific and is made by the CRA on a case-by-case basis. So like Sasha said previously, there's no one factor that's more important than the other. And the CRA will look at all the factors collectively when they are making a determination. So diving right into the factors then, the first one we're going to look at is the degree of financial risk. And when you're looking at the degree of financial risk of a worker, you're considering the degree of financial risk taken by the associate in the optometric practice. So for example, what's the remuneration structure for the associate? Are they being paid a salary, or are they, being paid a percentage of their OHIB billings? Is it some sort of combination? Are they being paid based on the hours worked or the services rendered? Are the associate's expenses reimbursed? So for example, professional liability insurance, any college or association fees that are due, any professional development and education. So if a payment structure looks like a salary and the payments are fixed, that would look more like an employment relationship and could be a high risk item that the CRA looks at. And contractors don't generally receive benefits, vacation time, or payment or reimbursement for education and professional developments, or any other typical benefits that would normally be received by an employee. And employees really, like Sasha said previously, won't really have any financial risk because their salary is fixed and their expenses are reimbursed. Whereas in an independent contractor relationship, that's quite the opposite. Hand in hand with the financial risk criteria is the chance of profit for the associate. So consider if the associate can realize a profit or incur a loss. Is the remuneration based on patients seen, or is it a fixed daily, weekly, or monthly amount? Could the associate's business expenses, for example, exceed their profits? So are they liable to pay for space or equipment or any back office support such as staff? And this factor is assessed from the associate's perspective. So can the associate control their own proceeds and expenses? Can they set their own fees? These are all things to look at and consider. Another factor is control over the associate. So consider the ability, authority, and right to exercise control over the manner and the type of work that the associate does. For example, can the associate set his or her own fees, or are the fees set by the clinic? Can the associate set their own hours, or are they required to be at the practice on certain days and certain hours? And does the associate have control over who they will accept as a client? It's difficult to determine these things in a professional setting given the expertise and specialized training of optometrists. And because of the specialized training, associates may need little to no direction in their daily activities. So if the answer to all of the questions that we have as an example above is yes, that would be more indicative of a contractor relationship. If the actual degree of control will vary with the type of work that's performed and the skill of the associate optometrist. Another criteria that we're looking at is the ownership of tools and equipment. So consider if the associate uses the clinic's tools and equipment to perform the services or whether they're required to supply their own. Is the associate required to pay for space and support? Again, this might be a difficult criteria to satisfy, especially if you have specialized tools and equipment that's used in the practice. And the control and ownership of the tools criteria also goes to whose responsibility is it to repair the equipment if it breaks down, and whose responsibility is it to ensure the practice and the equipment. And there are arrangements that could be made if an independent contractor relationship is in fact the desired approach. So for example, you could stipulate overhead fees for the use of space and equipment in an agreement with an independent contractor, which could be structured in a number of different ways, but there are ways to structure these clauses in agreements that would lend themselves more to an independent contractor finding as opposed to an employment finding, if the independent contractor relationship is in fact what's desired. Sasha already spoke a little bit about this topic, but I'll cover it quickly from the CRA perspective. So the ability to subcontract, consider the ability of the associate to subcontract all or part of the services to another optometrist or hire their own assistants. More than likely, your agreements, if you have agreements in place, will state that they cannot subcontract their services to somebody else. Employees are required to perform the work personally, no ability to subcontract, and independent contractors typically are able to subcontract. So for example, if somebody goes on an extended absence, and that could be similar to a locum concept with hospital physicians. But by their very nature, clinical roles don't simply allow you to subcontract your obligations to somebody else. So this is really a difficult factor to address. And the last factor that we're going to touch on today from a CRA perspective is the degree of responsibility for investment and management. So, as Sasha briefly covered before, you have to consider the degree of responsibility for the investment and management held by the associate optometrists. And a number of questions you could ask yourself are, is the associate required to make a capital investment in the practice? Does the associate manage their own staff? Does the associate hire and pay others to provide the services? All questions that you could think about and look at to consider whether truly the relationship is that of an independent contractor or an employee. So while a written agreement is evidence of the intention of the parties, the CRA and the courts and administrative tribunals will ultimately look at the actual practice of the parties. So whatever terms are reduced to an agreement must be realistic and applied in practice to withstand scrutiny. And there can be consequences to both parties if the intention is to have an independent contractor relationship, but the relationship is deemed to be one of employment. And those consequences can be retroactive EI contributions, CPP, income tax, employer health tax, as well as penalties and interests on unpaid amount and interest on the penalties. And for the associate, this could also have income tax implications. So if the intention is truly to have an independent contractor relationship, it's really important to look at all the factors, both from an employment law perspective and a CRA perspective, to make sure that if there is a finding or an audit by the CRA, that you would be able to justify the relationship. And whether or not the CRA will choose to review a relationship can't be predicted. So ultimately, you'll need to determine the degree of risk that you're comfortable with and that you're willing to assume in the event of an audit or in the event of a complaint.
Thanks, Meg. And just to reiterate what Meg said, the whole idea of the written agreement, it doesn't necessarily save you. If you're saying, oh, I have a written agreement that says this person's an independent contractor, if truly they're not, the fact that you have a written agreement from an employment law perspective won't matter. As we often tell clients, if it quacks like a duck and walks like a duck, it's a duck. So if in reality the person's actually an employee, it's not going to matter that you have this independent contractor agreement. It certainly helps, but at the end of the day, from an employment law perspective, decision makers will look at what the person's actually doing on their day-to-day basis. So there are certain consequences from an employment law perspective if you do have an individual who's improperly classified as an independent contractor. In Ontario, we have the Ontario Employment Standards Act. It is actually a breach of the act to treat someone like a contractor if they're in fact employees. I have to say that bullet 2 shouldn't be there because duly registered practitioners of optometry are actually excluded from some of the provisions in the Employment Standards Act, just like lawyers are in terms of vacation, holiday, and overtime. So apologies, that shouldn't be there. But there are still some parts of the act will still apply to an optometrist who's an employee. And then there's one of the biggest things I think is the potential termination and severance pay obligations that can arise, which would be if you end up terminating a relationship with an associate and it's determined that they were in fact employees, they're entitled to certain notice of their termination and in some instances severance pay. Now, I just wanted to touch very briefly on this dependent contractor category in case anyone has heard of it. It's kind of come up through our case law in the last few years. It's not a third category per se. What the courts have said is there's workers are either employees or contractors. If the worker is a contractor, then the courts will go and look to see if that person exclusively works for the organization. And if there is that exclusivity there, so it's a contractor, but they're exclusively performing work for a particular organization, that's where a worker might be deemed to be a dependent contractor. So whether they're a contractor, they're dependent on the work that's being provided to them by the organization. And in that particular case, if someone is truly a dependent contractor, the courts have found that they're still entitled to reasonable notice of termination like employees. So Meg and I are going to briefly touch upon what we kind of see as the key terms in associate agreements, having drafted many of them and kind of over the years seen what we think is probably most important. There's, several of them. Whether you're engaging an independent contractor or an employee, I think these provisions are super important to have in your associate agreements. And the first, and I'll briefly touch upon, is this concept of consideration, which I'll get into in a minute. You want to deal with patient records, non-competition, the services the associate will be providing, and the responsibilities of the associate. And again, we're going to cover this, but non-solicitation, perhaps even non-competition. How will the person be compensated? The fee structure. Confidentiality is a big one. Risk allocation, and then of course you want to deal with how does the relationship get terminated. So a consideration is a key piece to any written agreement. Whether you have engaged someone as an independent contractor or an employee, in order to have a written agreement enforceable, there has to be some valid consideration for someone to sign the agreement. So in a typical normal context, the consideration is you're engaging an independent contractor or an employee. That independent contractor or employee is getting certain benefits from that engagement. They're getting paid, for example. And so in exchange for that benefit, the independent contractor or employee signs off on the agreement. So the individual is getting something of value in exchange for signing the agreement. So typically it's the commencement of the relationship where you're going to have that valid consideration. What I often see happen is that someone might try and introduce a written agreement halfway through the engagement. So either you've been engaging an individual as an independent contractor or as an employee, and then someone says, okay, let's get this all in writing. Continued engagement is not valid consideration in law. And so in order to have that employment agreement or independent contractor agreement enforceable, if you've already had this relationship ongoing, you have to provide that individual with something of value in exchange, because they're already getting everything that you've agreed to. So if you want them to sign off on something, you have to give them something extra. Sometimes I see that as in an employment context, I often see it as a signing bonus. In an independent contractor context, you can often see it as like an increase in fees. It doesn't have to be much. There's no magic number. It just has to be something of value that the individual is getting in exchange for signing this agreement.
And another key term in an agreement with associates is, what services is the associate actually providing? What are the days and times for the service delivery? What are the standards for delivering the service? So you'll want some provisions in a contract that, for example, require compliance with the law and require compliance with the college rules and optometric standards of practice. Are there requirements to notify the practice of any absences or vacation? All these things are important to consider, both from an employment perspective and an independent contractor perspective, regardless of the type of relationship. These are the kinds of terms you'll want reduced to paper to ensure that there's a meeting of the minds about what services are actually being provided. Another key item to consider are the associate responsibilities. So one of the responsibilities we strongly recommend be included in contracts is the maintenance in good standing and registration with the college and their obligation to pay college dues. And this obligation should continue throughout the life of the agreement. It should not only be a requirement when you enter the relationship that the registration be maintained in good standing. It should be maintained throughout the term of the relationship. Compliance with policies and rules of the practice. The associate's required to comply with any rules, policies, procedures, guidelines that the practice and the clinic may have. Payment for use of space and equipment. So as we covered, one of the factors that the CRA will look at is, does the associate own their own equipment? Do they have to provide their own, or are they using the equipment provided to them? And if fees are being charged for use of space and equipment, what are those fees? When are they to be paid? What are the penalties if the fees aren't paid? And then on the other side, also in terms of clinic responsibilities, if you are in fact providing equipment to an associate to use, what equipment are you providing, if any? And what are the principal optometrist's responsibilities? All these things should be clearly stated in your agreements. Of course, compensation and fees is a very important topic. So will the associate be paid an hourly fee, or will the payment be structured based on the services rendered? Will they be paid a fixed salary? So what's the compensation structure? Are they being paid a percentage of the fees billed? These are all different ways to structure payment arrangements. And again, there's no one size fits all. It just depends on the arrangement that the parties choose to have. Another question is, will the associate get any benefits? So health, dental, extended health. Again, remember that benefits and vacation time and compensation for professional development are really indicia of an employment relationship. So really care must be taken when drafting these clauses and turning your mind to whether you intend the relationship to be that of an employee or an independent contractor. And then term and termination. So how, when, and by who can the relationship be terminated? Is it on notice? Maybe, for example, on 30 days notice, either party can exit the relationship. Can the agreement be terminated due to non-compliance or breach of the agreement? Can the agreement be terminated if the associate has their registration with a college suspended or loses their college registration? And then consider also obligations on termination. So for example, completion of patient records, both financial records and health records. If there's any equipment that the associate uses, consider the return of the equipment and what condition the equipment has to be in when it's returned. Now, speaking of patient and client records, the contract can specify the associate's right to access certain information if the relationship breaks down and the agreement is terminated. So for example, there's provisions under the Personal Health Information Protection Act that permit disclosure of information such as patient records for the purposes of a college or a court proceeding. But if the relationship does break down, the agreement should have terms around access to patient records, so that access is needed in the future. And of course, going along with termination is the term of the actual relationship. So when does it start? And the agreement should really be clear about the duration of the relationship. So is it ongoing? Is it for a fixed period, such as a year, 2 years, 5 years with a right of renewal? Consider also a review of the agreement. If it's a long-term relationship, there are clauses that can be built into these agreements, regardless of the structure, to the parties to come together and take stock of the relationship and review the agreement. And agreements can always be amended by the parties. If there's mutual agreement, there's nothing to say that an agreement can't be amended. So another clause to consider building into the agreement.
Thanks, Mike. Another really important clause would be dealing with confidentiality. So of course, you want to make sure that you're protecting client records, and not just client records or information about clients, but also any practices or procedures of the particular clinic that you wouldn't want released out into the general public. Of course, you want, at the end of the relationship, as Meg already pointed to, any return of client information or confidential information. You wouldn't want someone to leave the clinic and then take that information with them. And you want to prevent disclosure of client or clinic confidential information by the individual that you're engaging. And that's obviously a really important protection that you'd want to include. So the last topic we're going to briefly cover is this idea of protecting your practice goodwill. And we thought this would be a good topic because we get a lot of questions about this. And this is about this idea of restrictive covenants. And I'm sure many of you have heard of non-solicitation covenants or clauses or restrictions. And then there's also a concept of non-competition clauses. Which are common, but not as common as non-solicitation clauses. And I thought it would be apt to kind of give you a quote from the Supreme Court of Canada, which I really think shows how courts generally treat these clauses. Supreme Court of Canada has said restrictive covenants give rise to a tension in the common law between the concept of freedom of contract and public policy considerations against restraint of trade. So if we turn to the next slide, at common law or court law is what we call it, restrictive covenants are on its face void and unenforceable because courts find it's contrary to public policy. They don't like the idea of restricting somebody in their ability to earn a living. That being said, it doesn't mean that they're not always unenforceable. You can have an effective and enforceable restrictive covenant, but first and foremost, it has to be reasonable. You can't restrict somebody from practicing optometry in all of Canada. That's just never going to work. It's way too broad. And I mean, I think another factor that the courts will look at is there has to be some sort of proprietary interest that the clinic is trying to protect. That's typically your client relationships, and that's not that too hard to establish. What is challenging is kind of meeting this concept of what is reasonable, and of course it will depend on each situation. The court will also consider whether there's a less restrictive way to protect the interests that you're trying to protect. So there's no bright line test for reasonableness. As I said, it's really completely factually dependent. And it's also important to keep in mind that the courts have said if any aspect of a non-solicitation or non-competition clause is deemed to be too broad, so whether it's too broad from a geographical perspective, it's too broad because the scope is too large, or the time or the length of the restrictive covenant is too long, then the whole covenant will not be enforced. So it's not like you can save parts of the covenant. So you really have to try and get it right the first time. And so when courts or decision makers are assessing whether a restrictive covenant is reasonable and ought to be enforceable, the court will look at such factors as the nature and type of business, the nature of the relationship between the parties, what are the range of activities that are being restricted by the clause. The courts will also look at the geographical restriction in the clause, and this is a big one, and it does depend on where you are. A small town versus a big city will be different. If you're in a small town and there's only 3 practices and you've restricted this person from working at any of those practices, how are they to earn a living? Whereas in the city of Toronto, there's lots of practices, so you might be able to get away with a larger scope because there's more areas, more places to practice. So just to kind of cover really briefly that there are non-solicitation clauses and non-competition clauses are distinct restrictions. A non-solicitation is typically you're trying to prevent the former associate from soliciting or stealing the clinic's clients, whether it's indirectly or directly. And associates, if there are associates on the line, I'm sure you've been asked to sign these kind of clauses, and that's typically what a non-solicitation clause is. Thou shall not solicit our clients. They're typically viewed as less onerous than a non-competition clause because you're not restricting somebody from practicing, you're just restricting them from soliciting your clients. So non-solicitation clauses, they can apply to a restriction on soliciting clients. It can also apply to a restriction on soliciting employees or contractors of the practice, because sometimes organizations don't want someone to leave and then take all their employees with them. And so, I mean, really an appropriate non-solicitation clause would be to offer enough protection to the clinic and its client relationships and employment relationships without unduly compromising or interfering with the person's ability to work. With a non-solicitation clause, the whole point of it is that the associate can't solicit one of the clients. It doesn't mean that if a client chooses to follow an associate that they can't do that, because that's the client's choice. You've just restricted the associate from soliciting that client. But if the client really truly of their own free will decided to leave and go to that associate, a non-solicitation clause typically does not prevent that. And I just wanted to give an example of a non-solicitation clause. I'm sure you've seen many of them. Here's just an example. You agree that during the course of your, let's say it's an employee, your employment with the clinic, and for a period of 6 months after that employment comes to an end, regardless of the reason your relationship with the clinic ends, you shall not in any manner, directly or indirectly, solicit or otherwise induce any other employee, consultant, or contractor of the clinic to leave his or her employment with the clinic, whether to join a competing business or for any other reason. So that's with respect to employees. Again, that doesn't prevent an employee of their own free will deciding to leave and follow someone. It just means that the associate can't solicit them or encourage them to leave. And then with respect to solicitation of clients, it's a similar type clause. But again, another example is you also agree that during the course of your employment for a period of 6 months, you will not in any manner solicit any of the clinic's clients or prospective clients with whom you have or have had business dealings of any type on behalf of the clinic within the 12-month period. It's quite long. But what this one is trying to do, it's very specific, right? It's not saying you can't solicit any client of the clinic. It's saying if you actually had dealings with that person, with that client, within the 12 months prior to you leaving, those are the clients you can't touch, which makes sense, right? They already have a relationship with that client, and so you don't want them to capitalize on that relationship when they leave and try and take the client. If they don't have a relationship with the client, you're not preventing them from doing that. And the 6 months is just an example, by the way. It doesn't have to be 6 months. Again, that kind of depends on the circumstances, but certainly in some situations it can be longer. Now, with respect to non-competition clauses, these are harder to enforce. The courts don't like them. The courts think they're a restraint on trade. You're basically preventing somebody from competing with you. And courts don't like that because they want people to earn a living. So it's one thing to say you can't go after my clients, but then to say you actually can't work in competition of me, that's kind of going an extra step in terms of restricting the individual. And courts will consider whether a non-solicitation clause can actually affect what you're trying to achieve. And if it can, then the non-competition clause will be struck. So just to give you an example so that you can kind of see the difference between the two types of clauses, and I won't read the whole thing again, but in this particular example, you're precluding someone from carrying on an optometry practice, which is directly competitive with the clinic, or even practicing optometry anywhere within a particular geographic region. Now, with respect to drafting these types of clauses, there's a lot. It may be one paragraph, but there's a lot of thought that needs to go into that one paragraph. And so, I mean, of course, you need to think of, do you need a non-competition clause, or is it enough to have a non-solicitation clause? What are you really trying to protect? Are you trying to protect your client relationships? Or are you trying to protect someone from competing against you? And so when we're looking at drafting these clauses, one big component of the clause is how long is the temporal restriction going to be? And what I mean by that is how long will the clause be in effect after the person leaves you? So what you typically think of is how long do you really need to replace the associate or reestablish those client connections? Whether it's a non-solicitation or non-competition, you can't have a 10-year restriction on it. That just will never fly. You know, maybe it's a year, maybe you need 1 year to kind of rebuild that relationship with your clients. Maybe it's 6 months. There's no hard and fast rule, but it has to be reasonable. I certainly don't see much beyond 2 years at the most, and 2 years is kind of the max that I see. I mean, I've seen people try for 3, 4, 5 years, but they don't have success with that. Another really big component of these clauses is the geographic scope of the restriction. And again, like I mentioned before, that in part will depend on where you're working. Are you in a big city? Are you in a small town? Where is your clinic in relation to the next clinic? And you want to limit it as much as possible in terms of the scope of the geographic restriction. You don't want to prohibit someone from practicing in the city of Toronto, because that's probably too broad, and it wouldn't be deemed as reasonable. So you really have to give some thought to that geographic scope. Another thing that you have to keep in mind is you want to make sure it's not ambiguous. Somebody reading it needs to understand exactly what the restriction is. What are they precluded from doing? And people may sign off on these, but at the end of the day, if there's any ambiguity in it, it will be hard to enforce. So you have to be very careful with the language that you use. And in terms of the prohibited activities as well, you need to be really clear as to what the person can do and what they can't do. And then at the end of the day, you just need to consider overall, is this fair? Is it fair? Because courts will look at that. Is it fair what you're restricting this person to do? So I just wanted to give you one really quick case example, because I always think it's more helpful to put this into actual reality and practical context. And this is a case involving an eye care service called Iris. And they sold eyewear products at outlets, and they also employed optometrists to assess with their vision and prescriptions. And one individual, he was an optometrist, and he was contracted to provide services by the organization from 2007 to 2016. And then in 2016, he decided to leave, and she decided to leave and set up her own optometry practice, which was 3.5 kilometers away from where she had worked. And at the outside of the relationship, she had signed a non-compete agreement, which was for a period of 3 years, and the restriction was within 5 kilometers of that location. And the activities that she was precluded from doing was carrying on, engaged in, interested in, or concerned with the business that competes with IRS. So the Court of Appeal found that both the temporal and geographic limitations were reasonable. In other words, the 5 kilometers was reasonable, the 3 years is reasonable, so that's actually on the higher end that I see, but they did think that was reasonable. What was not reasonable was the description of the prohibited activities. The court thought that that was too broad and ambiguous, and the clause was struck. And if you look at the prohibited activities, it is pretty broad. Carrying on, engaged in, interested in, or concerned with a business that competes with IRS. I mean, someone could just be interested in any business, right? So it's hard, it's ambiguous and certainly broad. And so for that reason, the whole clause was struck. So I just thought that was a good example to kind of show you how this plays out in reality if it does go to court.
Thank you, Sasha. And we're mindful of the time, so we're going to summarize our session briefly today. So we did talk about the regulatory requirements around independent contractor agreements and how the Optometry Act and the college requirements around independent contractor agreements don't actually apply to associate agreements, working in association with other optometrists. So even though there's no legal requirement to have a written agreement between a clinic and an associate, we do strongly recommend that a written agreement be in place to protect both parties. And when determining whether the relationship will be one of employment or independent contractor, it's really quite important to consider the CRA criteria and the employment law requirements and drafting key clauses in your agreements. And of course, like we said before, remember that there's really no one size fits all for a contract. Relationships are different across different practices, and the courts and the CRA will look to the actual relationship, not just what's reduced down to paper, to determine the status of the parties. And like Sasha spoke about. And like with any other clause, really special care should be taken when drafting these restrictive covenants to ensure that they're enforceable in the event that there is a relationship breakdown. And at the end of the day, we just want to emphasize to you that the agreement is a tool, and it's a tool for you to use to set out the expectations so that in the event that there is a dispute down the road, both the clinic owner and the associate will have something to point to that will document their intention at the outset of the relationship. And so with that, we've concluded our presentation. We invite any questions that you may have. You can enter them in the questions box on the webinar. And if you do think of some questions later on that you're not able to ask today, our contact information is up on the slide. And as well, if you're an OAO PLI member, you do have access to the Miller-Thompson on-call program. So you can contact us through the Miller-Thompson on-call email that the OAO can provide you as well if you have any additional questions on topic. So with that, I thank you and I invite any questions.
And thank you, Meg and Sasha. I really appreciate it. So I will now share the questions you've submitted. So we've got some questions here for both you, Meg and Sasha. The first question, is it okay for an associate to be on the group benefits of the office, but paying his or her own fees?
I think putting someone on benefits of the office tends to be more indicative of an employment relationship because typically non-employees don't get benefits. And I think probably from a CRA perspective, it's a similar response. I mean, again, it's not the only factor though, right? So if that's all you have is that you've given this person benefits and everything else is more indicative of an independent contractor relationship, then I don't think that on its own will be a deal breaker. I think it will just depend on kind of the scope of the rest of the relationship.
Yeah, that's right. And I completely agree with that as well. If the associate does pay fully for their benefits, that might be something that the CRA will consider as well when making a full assessment of the relationship. But like Sasha said, it'll be a more holistic approach, and they're going to look at all the factors collectively and not just one factor independently of the others.
Okay, thank you. Next question, can you elaborate on HST remittance responsibility for associates?
I guess we can do. For associates specifically, I mean, typically in an independent contractor relationship, you have an individual who's being engaged to do their own business, and typically they would charge HST. You don't see that in every relationship, and perhaps maybe not in the optometry clinic relationship. And again, it's not like a requirement. There's no rule that says you have to do it. It's sometimes a factor that helps a classification of an independent contractor, but I don't see it all the time.
Okay, thank you. The next question, if you are in a part owner of one location, only in a multi-location practice, are non-competes for all other locations justified? Does that make sense?
If you are a part owner in a
at one location, and it's part of a multi-location practice, or non-competes for all of the locations justified?
I mean, it's hard to answer kind of in a silo. Certainly, I don't know how many locations they are and how far apart they are. If they were all within a close enough radius, it could be enforceable. If they're half an hour, 45 minutes apart in the city of Toronto, perhaps not.
So there's different factors to be considered. Yeah. Another question, what's an average value of a signing bonus? Here's a big one.
I had a feeling there'd be a lot of employment law questions.
Somebody wants their Christmas bonus lined up here.
There is no magic number for a signing bonus. There is a really ancient case that said a peppercorn can be consideration. And I often say that to clients to just make the point that there's no magic number. certainly if you're going to ask someone to sign off on all these restrictions and that they weren't previously bound to, offering them $1 is probably not reasonable, and quite frankly, I probably wouldn't sign it if it were me. So you have to be reasonable. Part of it is you want people to sign it, and part of it is you have to think about what they're giving up in exchange. So there really is no magic number. Maybe a couple $100 sometimes I see. Like I said, sometimes I see it as a percentage increase in fees. So it really depends. There's no average number, because often I tell people give a signing bonus and they just do it, and I don't even know what they've done. But I often see at a minimum a couple $100, but again, there's no magic number.
Thank you. We have another question here. As an associate, if I will be purchasing 100% of shares of the practice I work at, and the current employees do not have a contract, will I have to offer an incentive for them to sign an employee contract?
If current employees are not on a contract,
they don't have one.
Yeah, in order to get them on a contract, you need to provide something of value to them. It doesn't necessarily have to be a signing bonus. It could be, I'm giving you benefits that you didn't otherwise have. It just has to be something new that they're getting in exchange for signing it.
Okay, thank you. I have another question here. As an independent contractor, am I protected by the law for honoring the same position upon returning from maternity leave?
As an independent contractor, no, I mean, you're not. If you're a true independent contractor, and that's the big question, and I don't know if you are, but if you're a true independent contractor, then you're not entitled to the employment rights that are under the Employment Standards Act, which would include maternity leave. That being said, a lot of places will probably still want to do it or give you the time off, but if you're a true contractor, you're not protected under that.
Okay. Another question, what is the remedy if the practice owner believes an associate has breached a non-competition clause?
Good question. So typically, if someone wants to proceed with it, if for example, a clinic or practice thinks that someone's in breach of a non-solicitation or a non-competition, typically the way to enforce it is you usually see kind of a letter that gets sent out, a nasty letter that says stop doing it, and you see if that can accomplish the job. You want to try and give people an opportunity to try and fix it, right? But if that doesn't do anything, then it just really depends on how much the practice really wants to enforce it or try to enforce it. They do have the option of commencing a claim, like a legal action against the individual, where they would say that they're in breach of contract, and see where that goes and potentially argue it in court. So it really depends how committed they are to enforcing it.
Thank you. So at this time, I'd like to thank Meg Berkovitz and Sasha Siegel for this insightful presentation, and Miller Thompson for partnering with OAO for tonight's webinar, which will be posted on the OAO website within the next few weeks. Please complete our survey as you log off. Thank you for joining us. Good night, all.
Thank you.
Thank you.